Here, let me show you. Here, Constitution of the United States. Now, we had to memorize the preamble of that. I still remember it.
You do?
Yeah. Here, I'll show you. Hold the book on me.
Okay. All right, go ahead.
Constitution of the United States. Why don't you just give me the first word, and then I know the rest.
Okay, we.
We.
We? We.
Are you sure?
I'm looking right at it.
Oh, we. We.
Thee.
Thee. We thee. We thee.
People.
People. We the people. We the people. We the people. We the people.
Of.
Of. We the people of
the United.
We the people of the United flag. Breathe. Wind. Wave. Star.
States.
States. We the people of the United States.
In order.
In order.
To form a.
Form a.
More perfect.
Perfect. To form a more perfect you.
Nyan.
Nyan. Union. In order to form a more perfect union.
S. Ta. Ble.
Ble. Establish. Establish.
Just.
Establish just,
Test.
Justice. Establish justice.
Ensure domestic tranquility. Provide for the common defense. Promote the general welfare. And secure the blessings of liberty to ourselves and our posterity to ordain and establish this Constitution for the United States of America. You want to run through that again, or do you think you got it?
I got it.
Good.
You learn something, you learn it.
I think we're as democratic a society as you'll find almost anywhere, and we were in the 18th century. Even though 2 out of 3 white males could vote, women didn't vote, blacks didn't vote, but of course nobody else in the world could vote except in British House of Commons, and even there, which was the marvel of Europe, even there only 1 out of 6 adult males could vote for the MPs, the members of the House of Commons. So by the standards of the time, we're by far the most democratic society in terms of who could vote, and I think in social structure as well. We had no great noble families dominating the society, which Britain still had. By every measure, we'd have to say, even with the presence of slavery and the lack of women voting, we had the most democratic society in the world at the time. If you're going to measure it against modern standards, of course not. But that's a little unfair, I think.
We are a democracy. Democracy in its meaning says rule by the people. And I am one of those who believes that the most important words of the Constitution are the first words, we the people. It's so basic that we just come to take it for granted. For the framers and those who voted on ratification and just ordinary people, those words, we the people, I still think are the ones that resonate the greatest. Because the idea that the people govern themselves, while commonplace today, was not commonplace at the time. It was a tremendous innovation. Prior to that time, sovereignty rested in the king. Americans, prior to the Revolution, many of them during the Revolution, didn't identify themselves as Americans first and foremost. They said, we are British. That's in the moment of the 1760s and early 70s. And only 10 or 20 years later, people have this notion that sovereignty belongs in the people. That is a tremendous innovation and a tremendous transformation. So American democracy is this notion that whatever else happens, power may shift to this branch or that branch or what have you. The people themselves have the sovereignty. Now that then leaves open all these questions for debate. How do they exert that sovereignty? Is it through Congress? Is it through state legislatures? Is it through the courts? Is it in the president? The sovereignty rests in the people. And their spokesman happens to be the president, which is different from this notion of the king. So however democracy has played out in all these tensions, the idea that sovereignty lies in the people has been consistent. What has happened, of course, over the years and for various reasons, is a tremendous cynicism has crept in, where while we believe in the abstract, in the Constitution's ideal that the people themselves rule, people have come to believe that somehow they've lost that power. And that cynicism is well placed, it belongs, and we need to ask ourselves what happened and how can we once again believe that the people themselves rule. But American democracy is founded on that basic principle. And that principle, more than any others, is what carries forward and what remains, I think, a model for other countries who try to imitate American democracy. There are a variety of explanations for this. The most important one is that it was written in a very open-ended way. They didn't know how long it was going to last. There was a lot of fear that it would only last a few years. As a result, they've kept the wording broad, and they purposely avoided using words that would bind future generations too much. One example of this is that the word slave does not appear in the Constitution. The word slavery does not appear. One reason that's given for why it doesn't appear is that the framers, some of them at least, knew and hoped that someday slavery would not exist. And so they wanted a constitution that would be relevant even in the era after slavery had existed. Now, they knew slavery was going to exist, and the Constitution does many things to perpetuate the institution of slavery, but they avoided using the word, and that's interesting. So one is that the language is such as to make it open-ended, and that's in contrast to other constitutions, which were often very detailed, very procedural, and thus needed to be revised in every generation. And they wanted something that would last. And so they were very purposeful about that. Another aspect of this is that Americans are in some ways a rootless people. They don't have a long history. There's a long continental history, but our national history isn't that long. The idea of a long-term written constitution then gains incredible power. It becomes important to have this written constitution, and the flip side is any threat to that constitution, that is, this idea that somehow you're going to do something to it that jeopardizes the whole thing, is felt as a threat to the whole fabric of the nation. Over the years, as the Constitution was interpreted between 1789, when it was ratified, and then, let's say, the 6 decades afterwards, it was pretty clear that those who were excluded most clearly were people who were not white. That becomes especially clear when Congress passes the first Naturalization Act in 1790, which has the word white in it, basically saying that only white people can become citizens, can be part of the constitutional system. So that's sort of the most obvious group. That would certainly then count slaves. It makes ambiguous the question of free blacks, who might be counted as within the Constitution if they were, let's say, citizens of the state of Massachusetts, but that would remain a debatable issue, which was still on the table to be settled when the Dred Scott case comes up in 1857. Women were certainly thought of as part of the Constitution, but not in a way that would be satisfactory to people today. That is, they were seen as protected by the Constitution, as having the same rights as the Constitution. But, of course, they couldn't vote. That's not said in the Constitution specifically, but that's clearly the implication of all the rhetoric around the Declaration of Independence and the Constitution that says men. But of course, sometimes it just says people, and there were women who say, well, that means us too. But generally, lawmakers understood women to be people who were eligible for rights, eligible to under the Constitution, but who would be represented by men, either their father or their husbands. This was an age of dependency, so women were dependent, children were dependent. They were represented in the Constitution, but not in the same way that adult men would be represented. Probably the most complicated group are Native American. They're the only group that's actually mentioned in this way in the Constitution, in this phrase, Indians not taxed, as people who are excluded. The implication being that if there are Indians who are taxed, that means these are Indians who have been integrated into the constitutional system. So Native Americans represent the sort of most clearly excluded group, but at the same time a group that is given a path in. That is, they can convert to Christianity, they can become property owners, taxpayers, and then they can become part of the system. That's how it was envisioned and how it was executed by treaties over the next decades.
We find it inconceivable that one person could own another, and it's very difficult to get students to appreciate the fact that intelligent, well-intentioned people in the past could own slaves without the slightest bit of guilt. And you have to understand that slavery existed for thousands of years without any substantial criticism. And it's the 18th century where you begin to get substantial criticism, and in the American Revolution you get substantial criticism. The first anti-slavery society convention in the history of the world was held in Philadelphia in 1775. That's not coincidental, that the call for liberty created a problem for slaveholders that they never had before. You find no guilt in William Byrd, for example, who was a previous generation, 1720s. In all his vast diaries, he's a large slaveholder, and he has no guilt whatsoever. He's an educated person, one of the most educated in all of the South, in Virginia. It's the next generation, Thomas Jefferson, raised in a slave society, that comes to question it, which is quite extraordinary when you think about it, that he's brought up in a slave society, owned slaves, his father owned slaves, and yet he comes to criticize it. I think that's what needs explaining. What happens? And from that moment on, the slaveholders are on the defensive. The momentum shifts at the Revolution, and suddenly the slaveholders are put on the defensive. That they'd never been. No slaveholder in the history of the world was really ever on the defensive, going back to the ancient Greeks. It's hard to appreciate how long it was. Of course, there was nothing like American slavery and the movement of, 10, 12 million people across the Atlantic, and that's a story that has to be told. But one has to appreciate why it existed for so long.
We live in a culture, and have lived in a culture for more than 100 years, where we often think of the amendment as the obvious remedy to something that's a failing in the Constitution or something that's missing. For example, if you have a certain idea about the death penalty or about voting rights or even about abortion, it's a common thing to react to this by saying, oh, we need an amendment to the Constitution, especially if you're unhappy with a Supreme Court decision. The natural remedy then is a constitutional amendment for or against an issue. In the first 70 years of the Constitution's being, people tended not to think about amendments in this way. That isn't to say that they didn't think that the Constitution evolved. It did evolve, but it evolved through interpretation, either by the courts, by legislatures, especially by legislatures, the people themselves in their legislatures passing laws. And then over time, the Supreme Court gains greater and greater interpretive power. We live in an era today where we see a tension between those who want to ask, what did the framers of the Constitution mean when they wrote it? And those who say today, we should make our own decisions and not be bound by the hands of the dead, those who wrote the Constitution. And a wonderful example of this comes in the 1980s with Ronald Reagan's Attorney General, Edwin Meese. And Meese gives this famous speech in which he says, we should look at what the founders said, and we should look at their public statements and make those what bind us. And so he said, let's look at what Madison said at the time. Madison is often sort of celebrated as the founder of the Constitution. And we should be bound by what he said. So if he wasn't talking about women as voters or about this issue or that issue as being something that should be in the Constitution, nor should we. And a legal scholar responds, actually a historian writes this wonderful law journal article that says, Mr. Meese, meet Mr. Madison, and says that Madison himself would never have agreed with this way of thinking about history, that Madison did not think when he made any of these statements that they were meant to bind people later on. And so Madison himself, who's being invoked for this kind of way of thinking about history, Madison himself would have been against it. The idea of abolishing slavery was an old one, and the way to abolish slavery had been something that had been done by the states rather than by the nation. And what happens is that during the Civil War, with the war comes emancipation done by wartime proclamation, by military action, basically. And that is effective to a point, but only to a point. And there is an awareness of abolitionists and of free blacks and of even the slaves themselves, that abolition needs to be grounded in more certain law. And with that comes the debate over how to do it in the best secure way possible, that is to make emancipation and black freedom secure. Lincoln's choice tends to still be this idea of doing it through state legislation at first, but a number of abolitionists take this step and say, you know, the only way to really do this right is to change the Constitution. And it comes out of a couple places, but one of the most important places is the notion that many of the actions during the war, both military actions and congressional legislation, have been of dubious constitutionality. And Lincoln's Emancipation Proclamation, which he signed on January 1st, 1863, is itself perhaps unconstitutional. So the best way to secure emancipation and to respond to the possible objections is to do it by an amendment. And it's the first time then that a social reform is achieved in this way by an amendment.